Good morning, everyone. I think we need to fix this tone, please. Thank you. Okay. Good morning. I'd like to call the meeting to order and remind members to please turn off all electronic devices to silent. I would also like to advise that the meeting is being recorded or live streamed. The Niagara Peninsula watershed is located on the traditional territory of Indigenous people, dated back countless generations. We want to show our respect for their contributions and recognize the role of treaty making in what is now Ontario. This is our first meeting with me being the chair for the full amount. If everybody could take their drinking glasses, please, and turn them right side up. And if you put your hand up and I don't see you, I would just like you to do this. You get my attention that way, because it's not a fitness class. It's a wedding. Only we're not doing what you want us to do. Okay. So, Mr. Clerk, is there any changes to the agenda?
Do have a third delegation, so in order to allow the third delegation to proceed, we need to pass a motion to waive the procedural bylaw. It requires a 2/3 majority.
Thank you, everyone. So according to our bylaws, we only allow 2 delegates. Today we have 3. We're asking you to move a motion to allow the third delegate as per our bylaws, and it takes 2/3 of the vote. And I believe we need to do that recording, or we can just do it by hands. So we got a mover and a seconder, please, for waiving of the rules. And we got Member Clark, Member Hewson. All those in favor, hands up, please. And it looks like a vast majority. We're good. Thank you. So is there any changes to the order of the agenda, please?
I do believe our delegation
I think we need to do this.
Sorry, I believe our second delegation or presentation by Mr. Deluce is moved to after the public delegations.
Thank you. And just to explain to people, we all know that there's a lot of exciting things happening at Thundering Waters. So both Chandra and I asked that this topic be brought to this agenda today. So what we're going to do is Mr. Deluce is going to give us a presentation on the roles and responsibilities of conservation authorities. We are then going to go in camera and get solicitor advice from our lawyer. We are going to come out of camera. We are going to listen to our 3 delegations, and then we're going to have Mr. Deluce come back up and give us a presentation on Thundering Waters. So just to let you know, this is why it's a little bit different today, but I think it's appropriate given what's happening out there. All right, so can I please have an approval of the agenda moved by Member Brady and seconded by Bilsma, that the agenda be adopted as presented. All those in favor? It's a vast majority. There we go. Thank you. So now I'd like to, any declarations of interest? Seeing none, thank you. And then we have approval of the minutes. That the following minutes be adopted and recommendations therein approved. Before you are 4 sets of meetings. They're all from the full board authority. One is from December the 18th, 2019, and with that is the closed session meetings, December 18th, 2019, and the second meeting, it was dated January the 15th, 2020. Along with that is the closed sessions from there, 2015 or January 15th, 2020. So, may I have a mover and a seconder to approve all the minutes? Oh, sorry, thank you. So we have Member Wright.
I'm wondering, resolution FA 260-19 on page 4 of your agenda package. That resolution by Member Cable asking for a review of the floodplain. It's got the resolution, but not the preface that he had stated before that, and I think it's important because I think that gives the reason why Mr. Cable was asking for that resolution, and I'm wondering if that could be added. Mr. Cable's approval.
And just for clarity, Member Wright, which meeting are you referring to? What page are you on?
Sorry, December the 18th meeting.
December 18th.
And
page. Oh, sorry, I see it on P3.
I've got page 4, but the top of page 4.
Oh, correct. So you would like some Can you put your microphone on, please? Sorry. Thank you.
Mr. Kaywell had actually stated a bit longer resolution where he had given the reasoning why he was going to the caption resolution that you have here. I just think it's important, and you notice that for consistency, that other resolutions that includes the whereases and the reasoning behind it. And I'm just thinking, I'd prefer to see that included in this in the minutes.
So the full motion in the minutes.
Yes.
So is anybody from staff would like to speak to that?
I think we should have Steve. Steve?
Yeah. Through you, Madam Chair, no objection to the request.
Thank you. So we note that change. Was there any other changes before we approve? Seeing none. So can I please have a move? Oh, I've got one. Billsma and Member Metcalf, that the following minutes be adopted as amended, and the recommendation therefore approved. All those in favor for all 4 meetings. And it looks like a vast majority again. Thank you very much, everyone. And now we're going to go to correspondence. 4A, I've got 2 maps here, sorry folks. That the correspondence from the Conservation Ontario to the Honourable John Gabaski, I'm sorry, I'm horrible at this, Minister of Natural Resources and Forestry, dated January 17, 2020, the Ontario Special Advisor on the Flooding Report to Government, an independent review of the 2019 flood events in Ontario be received. Any questions about that? Seeing none. Do we have that? So it's been moved by Member Clark and seconded by Member Glen. All those in favor to be received. Thank you. And now we have the next one. It's resolutions from the Municipality of Dutton Dunwich and the City of Quinte West, dated January 15, 2020, to be received. And the recommendation is that the NPCA staff be directed to coordinate a joint request for municipal letters of support with other CAs that share jurisdiction within the City of Hamilton and Haldimand County. So it's moved by Member Cridlin and seconded by Member Brady. Sorry, I apologize. So it's moved by both. All those in favor with that direction? Thank you. It's carried. And the last one, Vice Chair McKenzie.
Thank you, Chair Johnson. On that matter, I was just wondering if the board feels it might be appropriate for the individual councillors to approach their municipalities and introduce this subject of these letters that have come from the other municipalities about approaching the Ministry of Environment, or will our office be sending out a letter to all of the municipalities? And if so, could that letter be copied to the individual board members who are representing the different municipalities so that we know when they might have received that letter so that we could go and have a chat with them to give our insight to that?
Yes, good morning, Madam Chair, to you.
We're fine, we're sharing.
Yes. I had a conference call with Conservation Ontario yesterday. They are preparing a sample letter for all of the conservation authorities, which we will use as a template, and we will send it out to all of the municipal clerks. And certainly, yes, we can copy our board members for further action on that.
Thank you.
I forgot to read the last part, that staff also be directed to reach out to the Niagara region and lower tier municipalities where appropriate to seek letters of support. So all within what Member McKenzie was suggesting. So we had it moved and seconded. All those in favor? And it's clear majority. Thank you very much. And the last pieces of correspondence and emails and materials regarding Thundering Waters from individuals as noted in the agenda and as provided electronically to the board members to be received. Just want to thank everyone who took the time to write their concerns to the board. And it's to be received and sent to the planner on the file of Thundering Waters. So it is moved by Member Metcalf and seconded by Member Foster. Thank you for printing. All those in favor? Serial killer or something here. Okay. All right, so now we're at presentations, everyone. I'd just like to invite Mr. David Deleuze, who is the Senior Manager of Planning and Regulations. I'm going to ask, just a second, David, I just want Darren, he just wanted to add a bit more preface here.
Through you, Chair. Yes, Mr. David Deleuze has been with the Conservation Authority since 2014. He is the Senior Manager of Planning and Regulations. He is the lead when it comes to our policy with regard to planning. He is also the lead on the Thundering Waters file as it currently stands. You're in good hands with David here, and he'll give you a very high level on the planning process and permitting process within the Conservation Authority during this presentation. And David, if you could just preface by advising of your credentials as well.
Okay, thank you, Darren. Good morning, members of the board, public. My name again is David Deleuze. I am the Senior Manager of Planning and Regulations for the Conservation Authority. I am a registered professional planner and also a member of the Canadian Institute of Planners. This morning, the presentation, just to give a brief overview for everyone's benefit of what exactly is the role of a conservation authority in planning process, our permitting process, and then the overall compliance process. So just a quick snapshot. I'm going to go over land use planning in Ontario. Then we'll go into conservation authority permits and how that process is different from the planning process. And then finally, in compliance, we'll talk about what's involved when we receive a complaint and what exactly the Conservation Authority does in its enforcement process. So first, how does land use planning work in Ontario? It's governed by the Planning Act, and that spells out all the different framework, the public consultation process, what a municipality can and cannot do, the different tools that are available to a municipality when dealing with any change in land use. So you hear things such as official plans, zoning bylaws, site plans, subdivisions. Those are all different tools available to a municipality under the Planning Act. The Planning Act and planning in Ontario is largely policy driven. So there's a hierarchy of policies. Lots of people have heard of provincial plans, the Growth Plan, the Greenbelt Plan, the Niagara Escarpment Plan, provincial policy statement, official plan, zoning bylaws. And again, there is a hierarchy to these policies. So starting with provincial plans, all decisions made by an approval authority must conform to those policies. Then, and those provincial plans, they apply to specific geographies within the province. They don't apply to all lands in the province. Provincial policy statement, on the other hand, that does apply to all lands in the province, and decisions by an approval authority have to be consistent with provincial policy statement. Official plans, there's upper tier official plans in the case of a two-tier municipal government. So in Niagara, you have the region of Niagara's official plan, as well as the various lower tier municipalities, their official plans. Finally, you have zoning bylaws. The thing to note about a zoning bylaw compared to all the other documents is the zoning bylaw is, when it comes to policy, it's a legal document. That's where you prescribe regulations, laws that somebody can be charged if they do not comply with the zoning bylaw. If someone doesn't conform to an official plan, there is no mechanism to bring someone up on charges or any type of repercussions for not conforming to an official plan. The policies in all of those documents, they cover a wide range of issues. So you're looking at environmental issues, social issues, transportation issues, economic issues. Basically all policies to guide how the province, how municipalities within the province develop, grow, prosper, thrive. Some of the decisions, most of the decisions actually, through the various planning processes, can be appealed to the local planning appeal tribunal in various capacities. So for example, someone doesn't agree with the zoning bylaw amendment, a member of the public can appeal to the LPAT. If someone looks at a site plan control application, again, a different process, if they don't agree with what the municipality is approved for a site plan, there is no appeal mechanism for a member of the public. That's only with the developer under that application. And there's constant changes happening to the legislation. So for example, last year the province recently amended the subdivision provisions to remove appeal rights for private citizens. Public bodies still have appeal rights for subdivisions, other agencies, but that was a big change, was removing the appeal mechanism for private citizens. So Conservation Authority's role in planning. So we have a number of different roles that we can play in a planning process. So first and foremost, we are a commenting body for most application processes. So that's prescribed right in the legislation that a municipality has to circulate a conservation authority. And also should note that we are a public body and we participate and comment on environmental assessments. So that process as well, we are circulated those various infrastructure projects by municipalities as well as individual environmental assessments. We have delegated responsibility by the Province of Ontario under Section 3.1 of the Provincial Policy Statement. So what that means is Section 3.1 deals with natural hazards. And the MOU we have with the province is between the Ministry of Municipal Affairs and Housing and the Ministry of Natural Resources and Forestry. And that gives us the authority to, on the province's behalf, provide comments on planning applications regarding consistency with Section 3.1. We are a service provider through agreements with other levels of government. So most commonly you hear MOUs with municipalities. We used to have MOU with the region of Niagara where we would provide comments on the region's behalf with respect to their official plan policies. So that's one example. Another example we've had in the past was an agreement with Department of Fisheries and Oceans for commenting or for doing the fish habitat assessment as part of their the protocol. We are a resource management agency, so we collect signs. It's been described by some colleagues in our office as we're a science broker. So we have good information on what's happening in our watershed in terms of the natural environment. So we work on watershed plans and developing that information and being a resource for municipalities in providing that kind of information. We're a regulatory agency, so we have responsibility of providing or reviewing permit applications in natural hazards areas that we regulate. So if somebody wants to develop or do alteration on a regulated area, they have to get approval from the Conservation Authority. And finally, we're also a landowner. So we do find ourselves from time to time in the situation where either we're making an application to the municipality and we are the applicant in that case, or we may be an abutting property owner and we would be commenting or circulating the application as a property owner and provide comments in that frame. A quick flow chart just to show you how the different processes connect. You have the Planning Act, Conservation Authorities Act, and then the Environmental Assessment Act, and again all the policies that fall underneath. Conservation Authority, we look at stuff through our policies, and we'll get into that in a second. So areas of interest. What areas do we have concerns with as a conservation authority? So first, source water protection. We are the Source Water Authority in Niagara, so we do take interest in source water matters. Again, those pertain to municipal water systems. Conservation Authority land, so our parks, our conservation areas, also just our overall land strategy, being on the lookout for lands that would provide strategic value to the Conservation Authority for furthering our conservation objectives. Regulated areas, that I think goes without saying. Watershed planning, that's a big area that unfortunately in the past we haven't been as active as we would like to be in watershed planning, but we are working at getting that up and going again and looking forward to participating with municipalities in conducting watershed planning. Natural heritage systems, again mentioned that we're a science broker. We collect a lot of good data on what's happening in the watershed. And one thing that we take interest in is helping to map out where are the natural heritage systems in our watershed, and that information can be very valuable to municipalities when doing high-level policy exercises. So, for example, the region is working on a new comprehensive official plan. That would be good information to help assist the region with establishing where natural heritage systems are. Niagara Escarpment. Even though the Niagara Escarpment falls under the jurisdiction of the Niagara Escarpment Commission, the Conservation Authority still has a regulatory role in the escarpment area. We regulate much of the land in there, either as a hazard or as valley lands. So we do take interest in what goes on in the escarpment, and we work well with the Escarpment Commission to make sure that development proposals, development permits as they're used in the escarpment, that those are reviewed by the Conservation Authority and that we make sure that our comments are heard. So what is regulated? We regulate watercourses, floodplains, wetlands and adjacent lands to those wetlands, valley lands, the Great Lakes shorelines, and hazardous lands. Now, most of those features are all defined by the Conservation Authority. So we conduct the mapping and the work that goes into identifying those features. Now, the one exception is provincially significant wetlands. We rely on the province just because of their role in identifying provincially significant wetlands. That information comes to us from the province. So other environmental features that are protected by other agencies. So first of all, significant woodlands. Those are, the criteria for a significant woodland is identified by the province. It comes out of the provincial policy statement and it's based on the Forestry Act definition of forest. And that is the responsibility of upper tier and lower tier municipalities through the provincial policy statement and their documents to provide the appropriate level of protection. One little side note on that is the Conservation Authority does have an agreement still with the region where we do the region's tree and forest conservation bylaw. We administer that. So that involves our forester going out and reviewing any potential infractions of that, as well as issuing good forestry practice permits for harvesting operations. Individual trees, those are not protected by the region under their tree and forest conservation bylaw. Those are up to individual municipalities to come up with, under the Municipal Act, a bylaw to protect those trees. There's other tools available to them. Some trees may end up being designated under the Heritage Act as a historic or a significant feature of cultural and heritage interest. Municipalities can also delegate that authority up to the region or the upper tier municipality to protect under their bylaws. But again, it's not a Conservation Authority regulated feature. Significant wildlife habitat, again, this is a criteria defined by the province and responsibility lies with the various municipalities. Endangered and threatened species, or also known as species at risk, that falls to the Ministry of Environment, Conservation and Parks. Used to be the MNR, but again, that is the ministry that deals with permitting and violations under that legislation, the Endangered Species Act. Fish habitat, that falls to the Department of Fisheries and Oceans. So, as mentioned earlier, we have a policy document in which we use to help guide our decision making. So, the Conservation Authorities Act gives us the power to create policies to manage our watershed. So that's where the authority comes from, to establish our own set of policies. The policies we use are to help guide staff in decision making when it comes to reviewing Planning Act applications as well as our own permits. So our current policies were approved in September of 2018. They did take effect November 1st, 2018. It was a long 3-year process that involved a lot of public consultation, a lot of meetings, and again, it was a pretty significant change from our previous policy document. So our policies generally are consistent with other Conservation Authority policies. So we're not too far one way or the other when you look at all conservation authorities across Ontario. The role of NPCA staff. So NPCA staff, when we get an application, we have a multidisciplinary team. It consists of planners, engineers, biology, hydrogeologists, we have restoration leads. So there's a comprehensive team that looks at applications. Depending on the nature of the application, what features are in question, it gets circulated internally. So when we review the planning application, we review the supporting studies as well. And we're looking at, for example, an environmental impact study. So that's a more common one that people think of. We look at one, is that study technically sound? Does the application meet the NPCA's policies? And are permits required at the end of the planning process? We work at keeping up-to-date science to assist with our decision making, so try to make sure that our mapping is current and up-to-date. And finally, we provide a letter to the municipalities with comments representing staff's professional opinion. So what is a professional opinion? Well, that's an opinion that has to be free from undue influence. So staff have to be providing objective advice to the municipality. It can't be influenced by anyone above, anyone below. It has to be an honest assessment of the policies in question and all the documents that were received. Do those documents meet policy? And then that letter gets provided to the municipality. So switching now over to Conservation Authority permits. Section 28 of the Conservation Authorities Act allows conservation authorities to make regulations. So through that, we get the power to establish our individual regulation, which is Regulation 15506. That took effect May 4th, 2006, and that was a big departure from our previous regulation. Previously, we only regulated watercourses and floodplains. As of 2006, we've now regulated wetlands, valley lands, Great Lake shorelines, hazard lands. So there's a number of new components that got identified through that process. And also just should note that in 2006, all conservation authorities in Ontario had their regulations come into effect around that same time. And all regulations generally have the same language and regulate the same features. Now, there's two specific sections within the regulation that pertain to regulating activities on properties. So Section 2 speaks to development, and that covers different areas such as the Great Lake shorelines, floodplains, valley lands, all the different components, wetlands that I just mentioned. Section 5 refers to interference, and that only deals with interference or activities in a wetland or to a watercourse, alteration to a watercourse. So a Conservation Authority permit is a separate process from Planning Act approval. When we're reviewing, we try to make sure that whatever is going through the planning process, that it's not going to be in conflict with Conservation Authority process when it comes out of the end. So there are possibilities where if a municipality makes a decision contrary to Conservation Authority recommendations and something gets approved that we can't support the permit, it puts us in a tough position where we have to deny the permit, and that can cause a hearing of the permit. Or conversely, Conservation Authority may have to consider appealing the municipality's decision if it's significant enough. Again, Section 2 mentioned that it pertains to development. Now, when we evaluate whether something conforms to that section, there's something known as the 5 tests for a Conservation Authority. So, has the control of flooding been addressed? Has the control of erosion been addressed? Have dynamic beaches been addressed? Has pollution been addressed? And finally, has the conservation of land been addressed? Now, the final point, conservation of land, through different case law and decisions that have come from the Mining and Lands Tribunal, there's been evolving definitions of the conservation of lands, and basically that is kind of a catch-all for environmental components. But to date, there's still no firm definition in the legislation. We've heard that through the pending regulation that might be coming down the pipe for conservation authorities, that they may address and define conservation of land, so we'll wait and see. Conservation authorities have to be satisfied that all of these tests have been made when issuing a permit. So when staff are reviewing the permit, we're looking at our policies, we're also looking at these 5 tests, and has the application addressed these 5 tests. So the permit process begins with pre-consultation with a proponent. So someone comes in, they sit down with us and say, hey, this is what I want to do. We'll advise them, okay, does that meet our policies, yes or no? What information do you need to provide with an application? Basically, it's to help a proponent be able to, one, know what they're getting into, and two, save time in the process by not having to come back after and ask for additional information. Following pre-consultation, if the applicant decides to proceed, they'll make their application. So we'll review the application against NPCA policies or regulation, and staff will either issue the permit or advise the applicant that the permit cannot be supported. If the permit can't be supported, the applicant does have the option to request a hearing of our board, and if the permit is refused at the board level, the applicant has the option to appeal that to the Mining and Lands Tribunal. This is just a quick snapshot of what the permit process looks like and the different outcomes that you can end up in. Again, just staff make the determination of whether or not it can be issued. If it can't be, it goes to the board, and if the board turns down the permit, then again, there's an appeal mechanism to the Mining and Lands Tribunal. Moving on to compliance and enforcement. Compliance involves ensuring that an applicant is in conformity with the conditions of their permit. So we do periodic inspections. We can't get out and get to every property, but we work based on a risk assessment of what properties are of a higher risk or what permits were of a higher risk, and those properties will be flagged for follow-up inspections. And again, we just go out to make sure that whatever work has been done is in conformity with the permit requirements. Enforcement, on the other hand, that involves bringing unauthorized works into conformity with the Conservation Authorities Act. So if we receive a phone call that, hey, somebody's gone out and started bulldozing on a property, we will look into that and make a determination as to whether or not there's been a violation. So presently we have 2 provincial offences officers, that's our regulations officers. They are the staff members that are responsible for doing compliance and enforcement inspections. Now, enforcement process, again, we receive a complaint or staff witness a potential violation. That's sort of the first step. We conduct a site visit and inspect what has taken place. So we'll go out, look at it, compare that to our mapping, and to determine, okay, what has actually happened. Is there a regulated feature or area on the property? If there's reasonable grounds that a violation has taken place, then we'll issue a notice of violation. And that's, at that point, what really kicks off the legal process. From that point on, it becomes a legal matter, and the information that can be released on what's going on becomes limited. It's protected under law, and it has to be preserved in order to maintain the integrity of the ongoing investigation. One thing to clarify, the Conservation Authority does not have stop work orders as a power under the Conservation Authorities Act. That is a section that is presently sitting unproclaimed in the legislation. We're waiting for the province to bring that into force. But if we go out and we witness somebody doing something and it's pretty obvious that, okay, they're right in the middle of a wetland, they're bulldozing through that, our staff don't have the authority to issue them on the spot in order to say, hey, you have to stop. Where we've done overlapping work with the region's tree and forest conservation bylaw, there is authority under that process to issue a stop work order. So if it overlaps with the Conservation Authority feature, we are indirectly able to issue a stop work order. Otherwise, if it's just a straight NPCA feature, we can't force someone to stop on the spot. You would have to seek alternative methods through the court, basically seeking a court injunction, which unfortunately takes time. So the enforcement process continued. If we find someone is in violation, it's not uncommon that the person may not have realized that there is a wetland there, or they didn't know where the boundary was. In those instances where it's relatively minor what has taken place, we'll work with the owner to try and bring them into voluntary compliance. So if the owner is willing to work with us, we'll work with them to help resolve the issue and restore whatever damage was done. If the owner refuses to cooperate and or continues unauthorized work, then the NPCA may seek laying a charge under the Conservation Authorities Act, which involves having to issue a summons through the court, and again, it's a time-consuming process. So that concludes my presentation. I guess if there's any questions, I'll be happy to take them.
Thank you. I've got Member Foster. Questions to this presenter, please.
Yes, thank you. Very good presentation, good overview. One of the comments that you made around policies is that we're generally consistent with other conservation authorities. Do you have, sort of off the top of your head, a policy that we're not consistent with? And I may have a follow-up question to that.
David?
Through you, Madam Chair. I don't know any specific policy where we're, I'll say, inconsistent with. We have, like for example, looking at septic systems. There's a number of conservation authorities that will have a minimum setback prescribed in their policies. Some have 15 meters as a minimum setback with an environmental study. Others have 30 meters. There's some conservation authorities that are just silent on that issue. Again, our policies, they're not out of line, like maybe consistent isn't the best word, but it's not as if the Conservation Authority has these overly permissive policies when you compare it to other conservation authorities.
And I think Chandra just wants to add to that, if you don't mind, please. Chandra?
Thank you, Madam Chair. It also depends on the nature of the conservation authority. Some conservation authorities have more rural policies because their jurisdiction is more rural. To give you an example of a more urbanized conservation authority, they'll have more water-related policies than a rural, like in an urban setting. So those are some of the subtle differences between conservation authorities.
Okay, Member Radley, and then we'll go to Member Woodhouse.
A new wrinkle in the systems is the biodiversity plan. And I know from my many years in Toronto and the Rouge that Toronto has passed a biodiversity plan. Now, I assume that's a municipality plan. I understand that Hamilton is working on one. So if they get passed, how would they fit into all this, or is that something we have to define as we go along?
David?
Through you, Madam Chair. There's a little bit of having to figure that out as we go along. Like, for example, our watershed has 3 municipalities, and Hamilton is one portion. So, we'll work with the city to help and be involved in that process. It depends to exactly how that fits into our program. Like, that's something that certainly our restoration team and our watershed management team would be interested in being involved in. But it's going to vary from jurisdiction to jurisdiction is what it comes down to.
Member Rapley?
It's just something we'll have to look at in the future. Now, if you get an opportunity, the City of Toronto Biodiversity Plan is on their website. I know they worked on this for many, many years, and it's very, very well done. It's very extensive, and it makes a lot of sense in the long run to have native species and ecosystems and try to work for the future. So just a point.
Thank you. Can you turn your microphone off, please? Member Woodhouse, please. Questions?
Thank you, Madam Chair. In terms of, I found this very helpful in terms of explaining in a, I think, easily understood format our responsibilities and our authority, which I think, Madam Chair, if it's agreeable, we should actually put this presentation on our website. I think it'd be helpful to the general public. In terms of questions that you get from the general public in understanding what's going on, is there, in your opinion, a good understanding as to the role and responsibilities that we have here with the authority and what our limitations are? The reason I say that is because I noted that you said in one specific, it does not have authority to, so there's obviously, that's for a reason, and I'd like you to maybe express a bit of your experience with that.
David?
Through you, Madam Chair. I think it would be very beneficial to provide more education for the public on what exactly conservation authorities do, because we do get, I'll say, a fair number of inquiries about somebody will call up and say, well, why aren't you protecting the woodland that's on there, and there's no other regulated area, and then you have to explain to that that member of the public why the conservation authority only looks at wetlands. So, and I realize that talking about policy can be a very dry topic, but I think there would be a big benefit from letting the public know exactly what the Conservation Authority can and cannot do. And it's not that the Conservation Authority isn't complacent and just that we don't care. It's we don't have the regulatory tool to be able to address the concern. That's the crux of the problem.
Member Woodhouse, I believe that Chandra just wants to respond to your comment about the website.
So, through you, Madam Chair, yes, along with this, the reason this presentation is here is because we understand that there is a diverse range of people out there with diverse range of understanding on what CAs can do or not do. What we also plan to do along with this presentation is have a Q&A. The question and answer will be, you know, if you are in a situation where, you know, a certain violation has happened, what do you do? So give people further information on what we can do for them or not will be very helpful. That's the plan to do that after this, yeah.
Thank you, Member Woodhouse, you still have the floor. We're done? Okay, thank you. Member Clark?
Yeah, just to clarify, Hamilton does not yet have a biodiversity action plan. I drafted the motion that is being debated today at General Issues Committee in my absence. I'm here where I am needed.
They lost 2 votes today.
Yeah. Hopefully it doesn't lose by 2 votes. I'll just die. But the Naturalist Club down there helped us draft the resolution, so the plan is over the next 2 years to put a biodiversity action plan in place with our climate change action plan, so that the two are holistic.
And for clarity, this is the City of Hamilton, not the Conservation of
Correct, the
Hamilton.
City of Hamilton.
Thank
Yeah,
you.
many hats, sorry.
Okay, and Member Houston.
Thank you very much for your presentation. I think we do have a lot of work to do in terms of providing more education to the public in terms of what the boundaries or the scope of or limitations of our abilities are. But I do want to talk about, you mentioned we have jurisdiction over woodlands, but we don't have stop work powers. So is it correct that when there is a clearing, we don't have the ability to, I guess, interfere in the infraction, only respond after the infraction has taken place? Move this way.
David?
Through you, Madam Chair, just to clarify, so a woodland in and of itself, the Conservation Authority doesn't have authority under its under the Conservation Authorities Act. In the case of Niagara, again, we have an agreement with the region where we are administering their bylaw on their behalf. So that is still, at the end of the day, a municipal bylaw, a municipal tool. But so the stop work order situation, again, unfortunately, if we go out on site and we witness something, like staff will attempt to go talk to whoever's operating equipment and if they see somebody on equipment, but if at the end of the day that person says, okay, thank you very much, and just gets back on and continues to go, there is no legal recourse. We can't just run off and hand them a ticket or something or instantly get the police to stop. There's not that authority in our act. We have to, right now, we would have to go to the courts to seek an injunction to compel the operator to stop.
So that would be a power that would have to be delegated to us by the province. Is that correct?
Through you, Madam Chair, yes. And again, there is a section in the Conservation Authorities Act right now that is unproclaimed, waiting for the province to give the green light for us to be able to issue stop work orders. So that has been in the works for a couple of years now. It was done in 2017, but there's, again, it just hasn't been proclaimed. So once that happens, we would then have those powers.
I'm just curious, does the Conservation Ontario have a position on that clause?
Chandra?
This is a major issue with most conservation authorities in Ontario. We are lacking on enforcement because of resources. We have 1 or 2 enforcement officers. There's a lot of big jurisdictions, so I think it's a common issue for most of the conservation authority. And yes, Conservation Ontario, in all of our comments, to the province during the process of Conservation Authority Act review over the last few years, and now have made those comments to allow us to, or equip us to be able to do that. Also allow us, better regulatory tools and enforcement powers to administer what we have been entrusted to do. Thank you.
Thank you. Member Laura?
Just one other item. You did mention that in certain instances we have the ability to lay charges, and when we do lay charges, I'm just wondering what the potential penalties are.
David?
Through you, Madam Chair, I would have to check the Conservation Authorities Act. I don't know off the top of my head what they are, but they are identified in the Act. I think it's somewhere in the neighborhood of a maximum penalty of $10,000 and up to, I think it's 90 days in jail.
Thank you. Members, Houston?
I just think it may be worthwhile for us to look at. Is that something we have control over, or is it's a limitation that's set by the Act?
Through Madam Chair, it's a limitation set in the Act. Yeah.
I'm just wondering if that's an effective tool and if the consequences are severe enough to prevent further infractions or future infractions, and maybe that's something we could look at.
Go ahead,
And
Chandra.
that's another, through you, Madam Chair, that's another area, very important point. It has been raised by many conservation authorities and Conservation Ontario. The value of that infraction and the fines does not even allow some of the conservation authorities, including ourselves, to be out there and charge the individuals, spend staff time fighting for it. Sometimes we end up spending more money dealing with that infraction than the fine actually is. So it has been, that comment has been made through our discussions and formal comments on the CA Act. But I think at this point it remains the same. I haven't seen any changes. David, I think you're right, it's $10,000, yeah.
Thank you. Member Houston, you still have the floor. Thank you. I have Member Metcalf, please.
Thank you, David. Very good presentation as well. Who sets the standard for what constitutes a woodlot or a significant woodland area? Does the province set that or the municipality?
David?
Through you, Madam Chair, it's the province. They have, again, when you read the provincial policy statement, it makes reference to the Forestry Act.
Thank you. Member Metcalf?
No, that's just, I wanted to make clear that that could be an educational thing as well, that it's all set by the province, not the municipality. Doesn't determine what is a woodland and what isn't a woodland, and their criteria is what sets our policies. Thank you.
Thank you. And I believe it was Member Smith. You had your hand up? Member Rapley's second time, so I'm going to go to him after we've done first time, please.
Thanks for the presentation, David. Appreciate it. It was good. I actually have 3 or 4 questions, so I hope you'll indulge me, Madam Chair. I wanted to know, to anybody's knowledge really in the organization, have we ever sought a court injunction to stop work, and what was the results of that if we did it? And I'm not sure if you're the right person, David. I know you haven't been here long, but...
David, success rate?
Through you, Madam Chair, I'm not aware of the NPCA seeking a court injunction. There was I'll say within the last 10 years, I believe there was a case in Halton region where Halton Conservation sought an injunction. But again, that process takes time, and yeah, there's a lot of legal work involved in doing that.
Thank you. Member Smith?
So if I can add a comment on my experience with court injunctions, because I've been involved with 2 actually involving this organization. They're not as onerous as they seem, and I'm going to throw that out there.
I'm just putting this out there right now. We're not here for debate. We're just here to clarify the presentation.
It will lead to a question on the presentation. They're not as onerous as they seem. in one case, we filed for a court injunction on a Monday, and then on Friday, we were in front of the judge getting a decision that led to this board being established. So what I'm wondering is, how do we as an organization go about making ourselves, I know that we say that we all believe court processes are timely and expensive, but if a case is important enough, a court injunction may be a viable thing. I've never heard of the NPCA doing it, but that doesn't mean it hasn't happened. So how do we as an organization make ourselves smarter than that? So rather than go through the assumptive analysis that we don't want to seek a court injunction in this case, so what else? Maybe we do want to seek a court injunction. So I'm saying, how do we get more information on that?
I'm going to ask the CAO to respond, David, please. Court injunctions? How do we make it more?
This is a new area of business for me, of course. Members may. We can look into that. So you can, as staff, we can go back and do some more search and see what the precedent is among all conservation authorities and what has resulted in that and the length of time. So we need to do more work on that. At this time, cannot say anything.
Okay, Member Smith, you still have the floor.
Thank you.
You had mentioned, David, MOUs with the region. Now, I know that we gave one MOU back, but we still have one. Actually, I'm just going to ask, can you give like a 30-second review of what are the MOUs that we still have? Is it just the one on significant woodlands?
David?
Through you, Madam Chair. We have an MOU with the region. We're technically not signatory to that MOU, but it's what the region uses for coordinating planning processes with all the lower tier municipalities. Now, we are referenced in that MOU, and we're indirectly part of that MOU through, it's getting complicated here, a protocol under the MOU, and that's what we've signed with the region. That is where we spell out who's reviewing what in terms of region's official plan, policies, stormwater management, all the stuff that we used to do. That's what gave authority to pushing that back to the region. The agreement we have, the MOU with the region, is a separate one for the tree and forestry conservation bylaw. As I understand, that is in the process of going back to the region as well once the region completes their tree and forest conservation bylaw update. We also have, just lack of a better description, planning MOU with the City of Hamilton and the other conservation authorities in Hamilton's jurisdiction, and also an MOU with the County of Haldimand.
Member Smith? No, your microphone again. Sorry.
So I wanted to ask a question on the, and this is actually the last question. We've heard that we're not so far out of line with other conservation authorities, but in reading the, so I'm going to say that the previous CAO, and this is going back 2 or 3 CAOs now when I say previous, made a public statement, or not a statement not intended to be public, that he was instrumental in turning this agency from an agency of enforcement to compliance. And also in the public's eye, this the NPCA has, in the last 4 years, I'm saying 2014 to 18, moved to a more permissive state of compliance. So is that a fair assessment, or are we actually suffering from just bad PR?
I don't know how to turn that question to David or to Chandra.
Yeah, I don't even know.
I think we're going to let Chandra give a
answered,
shot at this, and maybe
truth.
we'll get back to you offline later. Just Chandra?
Personally, I cannot comment what happened in the past or not, but I can tell you what the spirit and most conservation authority, the practice is overall. Yes, we've been given enforcement powers, through the province, but we also have a role. We are a grassroots organization. We got to work with public, and we also have this watershed mandate, which basically allows us to be working with our partners, whether they are municipalities or community members. So just kind of branding ourselves as an enforcement agency has not worked in favor of many conservation authorities. So the general approach is, yes, we are a natural resource management agency. Enforcement and is a regulatory piece of our work, but then there is a broader watershed management and natural resource management mandate where we are a value-added partner both to the community and the municipal partners, and we've had more success with that approach. Ed, that's my philosophy, and I think just by kind of permissive, yes, in many respects, on where we have to have collective impact and work with the community and partners, even stakeholders, even the development industry. Many conservation authorities have been able to achieve amazing things with the right developer, with the green mindset, and they have done amazing things. So I think it's a balanced approach going forward. I can say that. Just by being an enforcement agency doesn't help us meet our broader mandate. That's my opinion on that.
Thank you very much, Chandra, and I'm the same ilk. Whatever said in the past is there. So I'm assuming that you're finished with your questions, as you said earlier. Dr. Rapley, if we could just wrap up, please.
This will be quick, but it seems to me that the municipality of Niagara Falls should have some responsibility for this. And what have they done, and why have they not done anything?
Thank you, but we can't speak for the municipality, so
No.
that I know that was just a statement. I'm looking for questions, please, for clarity for the presenter and Member Brady.
Thank you. David, I know the question that was asked to you in terms of enforcement suggested that perhaps the Conservation Authority hasn't been as aggressive in the past as others. However, I'm aware that there are certain examples of where the Conservation Authority has taken people to court who have violated the certain things. And given the context that we're in today, I think it would be helpful if you could describe at least one where the Conservation Authority has effectively gone to court because someone violated a PSW and received a ruling, if you wouldn't mind.
David, an example, please.
Through you, Madam Chair, there is an example, without getting into too many of the specific details, but in Fort Erie there was, back in 2000, I want to say it was 8 when the actual violation took place. There was a property owner who had gone in and cleared out a portion of a provincially significant wetland. Over the course of the next couple of years, that owner was taken to court. I believe there was a guilty plea, and the court issued an order for the restoration of that wetland.
Thank you, Member Brady. Thank you. And those are all the questions. Thank you very much, David, for, oh, I'm sorry.
She always forgets me.
Understandably.
It's volitional. Can I just ask some questions in terms of authority? So when our staff are looking into planning applications, they're providing their unfettered comments to the local municipalities, and their comments do not come to the board for approval. Is that not correct?
David? We can have 3.
Through you, Madam Chair. Sorry, I'm blanking out here. When we comment on the applications, sorry, Member Clerk, could you repeat the question?
So when our staff, yourself and the expert staff that we have, are providing comments to municipalities on planning matters or approvals on planning matters, including permits, it's all based on the professional advice and expertise of the staff and it's unfettered, your decision, yay or nay, or comments that are provided to municipalities do not get vetted by the board of directors here. Is that not correct?
Through you, Madam Chair, that is correct.
And can we speak to the hearing process? So on a permit basis here, we also are a hearing body. So staff may or may not approve a permit that is applied for. And if an appeal of that staff decision is made by the citizens, where does that appeal go to?
Through you, Madam Chair, that goes to the Board of Directors.
And the reason I'm asking that question is, in my mind, the separation of governance versus administration. If the board was involved in decisions on planning comments or permits, and we were also the appeal body, then we have a conflict. So we stay out of the staff's position and authority. They make decisions based professionally. And if that gets appealed, then it can come here because we have not been involved. Is that not correct, David?
I believe that would be correct, yeah.
It's important that the public understand that because there is that component, although it's rare, it does happen in some municipalities more than, or some conservation authorities more than others. Thank you very much.
Thank you, and I don't see any more questions, so I'd like to thank David for his presentation. Much appreciated, very well timed. And it's been moved by Member Ingrao and seconded by Member Metcalf that David's presentation be received. All those in favor? Thank you. It's majority. So, as I stated earlier in the agenda approval, we are going to go into camera to get solicitor advice regarding potential litigation. I'm going to read this out. That the meeting of the Board of Directors of the Niagara Peninsula Conservation Authority convene in closed session at 10:32. Mine says 31. a.m. in accordance with Section 11.1 of the NPCA Administrative Bylaw for the discussion on A, advice that is subject to solicitor-client privilege, including communications necessary for that purpose, and B, litigation or potential litigation, including matters before administrative tribunals affecting the NPCA. So it is moved by Member Foster. Again, thank you for writing this. Member Metcalf that we convene into closed session. All those in favor? Thank you. And to the members of the public, we are doing this so that we don't waste your time at the end of the meeting and wait for the decisions. Please take all your personal belongings with you. I've had to take 4 or 5 coats out to the hallway the last time, and all your baggage, everything goes out. Thank you. We were in camera because we did have like a 10-minute recess for everyone to grab their coffees and have nature breaks. So we're now at the delegations. First of all, I want to apologize to all the delegations for the confusion that has been held for the last 2 weeks. In the city of Hamilton, we allow 5-minute delegations. So when I was initially speaking with them, I said 5 minutes delegations. Then they read the bylaw, it's 10 minutes delegations here at the NPCA. So then it went back and forth, 5:10, 5:10. So as it stands right now, we're going to follow our bylaw. It's a 10-minute delegation. At the 8-minute mark, I will give you a warning just to wrap up. You have 2 minutes to go. And also, and just as advice from the solicitor, just to let everybody know that there are some properties out there, one in particular that has had a violation, a notice of violation. This is not a hearing, and I'm putting everyone on notice that if we need to stick to general statements. Any statement that is specific to the file, either by name, the applicant's name, then I'm going to have to give you a warning, because we don't want anything that's going to impede the integrity of the investigation going forward. As a board, we cannot comment at this point in time. We will listen to the delegates. And I think everybody's under the understanding that this is a very respectful process, and we would like you to continue with the integrity of that respect. So I will give you warnings. One warning, the second warning, if you continue to be specific to a file, then I'm going to have to revoke your request to speak, just to protect the integrity of the investigation. All right? So the first up on the list is delegation by Liz Banyan, and this is the NPCA is contributing to the loss of provincially significant wetlands in Niagara, generally speaking. Good morning, or is it afternoon now, Liz? Oh, good morning. 2 minutes before.
How do I? You just click. Okay, we're good. Perfect. Good morning, Chair and Board, and thank you for allowing me to speak today. I'm actually going to be talking about why increased enforcement and stronger policies are needed to protect Niagara's PSWs. And the example that I'm going to be specifically speaking to today is what's known as the Southwoods development in Welland. So through lack of enforcement of protections for provincially significant wetlands, and through weak regulations regarding PSWs, these critical natural systems continue to be lost throughout Niagara. Improved enforcement, policy changes, and more robust reviews of EISs at all levels of government and at agencies like the NPCA are needed to stop this loss. It's important to understand that in Niagara, the municipalities depend on the expertise of the NPCA and the region in setting and enforcing environmental policy and providing the expertise needed to review EISs. Many of our 12 communities are small, and they do not have the staff with the expertise required to propose or enforce environmental policies or to evaluate environmental impact studies. With significant and growing flooding issues around Niagara and with infrastructure costs rising, with continued loss to our natural areas, with development pressure growing, there is an urgent need to ensure that there is consistent enforcement, natural area protection policies, and robust reviews of EISs in place. I'd like to bring your attention to an example of how the current situation fails PSWs. And like I said, this is the Southwoods development in the city of Welland. So a brief history. The M&R surveyed the site in 2009 and determined it contained a provincially significant wetland of just over 1.4 hectares. By 2009, a pond that was part of the original wetland was filled and turned into a turnaround. You can see that gray area down sort of in the middle, that round circular area. So that was part of the wetland and it was paved over. In 2010, an aerial photo of the area by M&R showed a 200-foot drain pipe clearly visible coming out of the ground. Disturbance to the land around it, including the clearing of vegetation and tree removal, demonstrates that the pipe was recently installed. The pipe was draining water from the wetland into a city sewer. There is no disagreement about this. I was at Welland Council on this issue a couple of months ago, and there was no disagreement that this is what happened. In 2012, M&R was to conduct new mapping as requested by the developer, but they couldn't do the mapping because all vegetation had been removed. M&R had to wait a year for vegetation to regrow. And during all three of these significant disturbances to the wetland, no enforcement action was taken by the NPCA. In 2013, the area was remapped. Given the significant drainage caused by the drainage pipe, the wetland area was now determined to be just under 0.9 hectares, 37% smaller. In 2014, with the drain pipe still in place, the developer's consultant did an environmental impact study that determined the area had now only 3 small wetlands, totaling under just 0.5 hectares. Only 49% of the M&R's mapping of the year before. The developer then tried at the ROPA 11 and again at the OMB to have the wetland designation removed entirely. Those requests were denied. In 2017, the NPCA issued a report grandfathering the drainage pipe because they mistakenly said it had been installed in 2004. As previously noted, the pipe was installed shortly before it was photographed by aerial surveillance in 2010. Sometime in 2017, the drainage pipe became clogged and ceased to function. The original boundaries of the wetland began to reappear. Aerial photos from 2018 and 2019 show that the wetland had resumed its 2009 dimensions. However, the developer wanted the City of Welland to accept the 2013 mapping from when the wetland was being drained. Comments on the EIS didn't comment on the possibility of remapping, although MNRF said they would be willing to review new mapping. The developer also requested a 15-meter buffer. The NPCA's comments support that despite the fact that much of the area in the proposed 15-meter buffer is underwater during the spring. As well, the developer wanted to work within the 15-meter buffer during construction, and the NPCA didn't have an objection to that. About half the area to be developed to the east provides surface water that recharges the wetland. Developing the almost 0.3 hectares of cultural meadowland could destroy the wetland. Here's what the EIS, the developer's funded EIS, says. The wetland's presence is dependent on local overland surface water flow from snow melt and rain events. Alterations of the surface water flows away from the wetland could result in either a reduction in the wetland area or the complete long-term loss of the entire wetland area. It's important to note that a natural spring at 65 Sumbler feeds the wetland through a drainage ditch running south to the PSW. The current plan calls for the removal and filling of the ditch and the development of townhouses 31 to 36 over that area. This would deprive the PSW of a significant source of water. In their comments on the EIS, no concerns were raised about protection of PSW water sources. Current regional policy also remains silent on protection of PSW water sources. The EIS appears to be inadequate in terms of identifying species and habitat in the PSW. For example, the EIS makes note of 22 species of birds, but makes no mention of the numerous water birds common to the area, such as ducks and geese, or the hawks and wild turkeys, all found in abundance in the PSW. The 2015 EIS says that no adult frogs were observed in the PSW between 2012 and 2014. However, chorus frogs, spring peepers, green frogs, leopard frogs, and American toads have all been observed in and around the wetland. The homeowner at 65 Sumbler, where the spring that feeds the wetland is located, says she has counted between 75 and 100 frogs at a time in her yard. The apparent inadequacy of the EIS in terms of fauna was not questioned. So the next piece here I had to write before I actually knew what happened, because Welland had a meeting on this development application last night, and talking to some of the councillors, we believed it was going to pass when in fact it was voted against. So they have voted against this development. It's going to the LPAT. However, they don't think they're going to win because they don't have anything, they don't have enough that they need to back up their denial of this application. In summary, wetlands are critical environments that have Important ecological and green infrastructure functions, and most of southern Ontario's wetlands have been lost. Here in Niagara, as the earlier map showed, most of our wetlands have been lost and continue to be lost. We need to protect what's left. The Drapers Creek wetland is an important PSW, home to innumerable insects, amphibians, mammals, and birds, and the NPCA could have enforced protection of it. The NPCA and the region...
2 minutes, Liz.
Yep. The NPCA and the region could have urged the remapping of the PSW and asked for a peer review of the EIS. The NPCA should review its policies on PSW buffers and put them in line with other conservation authorities' policies with minimum 30-meter buffers and without the long list of exceptions that currently exist within NPCA policies. It's important to note that provincial policy actually allows consideration of development impacts within 120 meters of a PSW. The NPCA should work with regional partners to enact consistent policies that PSW water recharge surface areas should be protected. Otherwise, there's no real protection for PSWs. The NPCA and the region should ensure work on land adjacent to buffers must be clearly defined and must not impact the PSW or its buffers. In conclusion, the NPCA and the region are currently contributing to the loss of PSWs in Niagara, with development pressure increasing, climate change making the green infrastructure value of wetlands more apparent, and with a biodiversity crisis occurring throughout our region. There is extreme urgency for the NPCA and the region to review and reform their policies and practices. That's it. Thank you very much.
And thank you, Liz. And just to let the board members know that both Chandra and I have made the commitment to sit down with Liz on this file and a few others to discuss further. So thank you very much, Liz. We'll receive all the presentations at the very end. And the next person coming up would be Dr. John Bacher. And Dr. Bacher, you understand the rules ahead of time and that you have 10 minutes, please.
Thank you.
Microphone, please.
Yeah, thank you. Click this one. Okay, thank you.
We won't be questioning the presenters on any of the information presented today then?
As we discussed in camera, anything that's before LPAT or anything that may be a potential investigation, we're not. And I understood from the previous speaker that it's currently going to LPAC. We're not going to make any comments at this time. Thank you. Sorry for the interruption, Dr. Bacher. You're on.
Yes, thank you. My thoughts initially focused on what I cannot speak to. I was thinking of referring to these areas as the official plan amendment 128 lands. Is that a proper way to discuss them? I hope at some point I will be able to receive questions on my written presentation, which is done with some care. One point that it goes to in considerable length was commented upon earlier by Mr. Deluce, because there is considerable discussion in the debate on this issue about who defines a provincially significant woodland. My view is the same as Mr. Deluce, that it is defined by the province. I agree under the terms of the Forestry Act. And that was used by the Niagara region as guidance when they designated environmental conservation areas. In the written brief I submitted, which I hope at some time to be able to discuss with you, there are the comments from the Ministry of Natural Resources, who is entrusted with interpreting the Forestry Act and why they believe these areas are covered under the Act. And that was a matter of dispute. And unfortunately, that matter was not known to the public till it was obtained by me with the help of a now disbanded provincial agency which no longer exists. Now, there are other issues that I'm trying to first discuss. What was not in my written submission, but it has been a discussion at the NPCA in the past. That is a wetland that was part of the Niagara Falls Provincial Slough Forest Wetland Complex. It was a wetland component on Dorchester Road that was known as a wetland, identified as wetland number 1 in a consultant's report. It was subsequently downrated by the ministry. Again, I would emphasize what you just heard from Liz Benyon about the wetland in Welland. It has all the plants that are supposed to be in a wetland like this. It has 2 critical indicator species that breed in this wetland: the western chorus frog and the blue-spotted salamander. It was not, in my view, downrated in accordance with the procedures for wetland evaluation established under the Ontario Wetland Evaluation System. I would also like to draw to your attention a water course that has been previously unidentified. It was called, in a study, Figure 15, Surface Water Feature DF1. It is important because that DF1 feature, which I believe to be the former Warren Creek, it feeds a provincially significant wetland that is one of the reasons that it supports bullfrogs and snapping turtles. We'll now go to my slide presentation. What you see is an area that should be considered significant wildlife habitat. That is what the area looked like this summer. It is dominated by the dotted hawthorn. The reason it is considered significant wildlife habitat is that there's 3 species that are declining seriously: the field sparrow, the brown thrasher, and the black-billed cuckoo. First, only time in my life that I have ever seen the black-billed cuckoo is in this area. Mr. Rapley told me how he once saw as a teenager the black-billed cuckoo in Hamilton area. It was a common species in his youth. It is now declining throughout North America precisely because of the loss of habitat as areas such as this. One of the sad things about this significance of these type of areas was once made clear in a natural areas inventory, which was produced by the Niagara Peninsula Conservation Authority, but for some reason inexplicable to me, was removed from its website. Still not on its website.
Dr. Bacher, you have 2 minutes to wrap up, please.
This is, you saw, this is what the area looks like today. Much more, it's typical of the loss of habitat that has made these birds declining at risk throughout North America. It also was, there's the another photograph of what the area looked at one time. The trees there that may no longer be there may include the species, the American plum, which was brought here by Native people. It is also an area that has been identified as a location for a provincially rare orchid, the Great Plains ladytress, which may still exist beneath the soil. We don't know. So I hope sometime I will be able to answer questions on this, because I've been involved in this matter for 12 years. This area moves me greatly. I hope it will eventually move you the same way that it does me. It's a haven for endangered species. It's a wildlife refuge in fact. It should be properly recognized in policy. One of the tragedies about this is the very study that would help it be recognized as policy was once on your website and is now removed, and I hope you will correct that situation before your next meeting.
Corrected. Thank you, Dr. Bacher, and I understand everybody heard the invitation from you to go and visit the site with you, and thank you for that. So now we have a PowerPoint by Linda Manson. Thank you so much, Linda. Linda and I had a bit of a chat beforehand, so I really appreciate your openness.
It's not a PowerPoint. Surprise. I was surprised too. But I do thank you for the opportunity to speak today, and I respect the instructions that have been provided to me, and with my friends behind me, we made some quick changes. My name is Linda Manson. I'm here to present 3 urgent issues about a file. Misstatement of NPCA wetland policy, bait and switch of provincially significant wetland buffers, and rogue era exceptions to the 30-meter rule. Issues in need of immediate board review to restore public trust lost over this file. For context, the backstory. The moral reality has a way of catching up with you. 5 years ago, when the developer bought the property for its master plan, the main obstacle was environmental protection. Almost half the 500 acres were designated PSW, provincially significant wetland. From the first meeting of March 2015, cited in the Auditor General's report, handwritten notes reveal the mention of a minimum 30-meter PSW buffer upset the developer's rep, and they responded by stating the simple reality. If 30-meter buffer required, the development cannot happen. The saga could have ended there. The purchase was not final yet, but the NPCA, under its rogue regime of the time, gave them hope. By putting this project ahead of its mandate to protect those PSWs, that too is a reality. As the Auditor General reported, senior management was working on a proposed project to allow wetland destruction in contravention of provincial policy, not based on any scientific analysis to determine the feasibility, a biodiversity offsetting scheme, relocation of PSWs. And other encouraging options were offered at that first meeting. The potential to develop within 30-meter buffers, if justified by an environmental impact study, was stressed twice. Roads through buffers, or even PSWs, were possible if they underwent environmental assessment. And the Ministry of Natural Resources and Forestry, MNRF, could be asked to revisit and revise wetland boundaries. The developer bought the property apparently convinced any policy obstacle could be overcome. But over the next 2 years, the project ran into reality checks, rejection of the offsetting scheme, designation of even more PSWs, and scathing criticism by MNRF and peer review. Apparent frustration over delays led to change of plans, developing in stages, starting with a small area. The secondary plan was abandoned, replaced by a community plan, an official plan amendment, approved by City Council in spite of major objections by MNRF, who cited flaws in the environmental impact study and advised the region to review it for failure to comply with provincial policy that there shall be no development or site alteration within PSWs in southern Ontario. Enter my first issue of concern, misstating of NPCA wetland policy. In its comments on that OPA application, NPCA contravened provincial policy by misstating its own, claiming Section 324(1)B allows roads through PSWs if supported by an approved environmental assessment, when in fact it permits some restricted uses, including roads in some wetlands, but only in non-PSW wetlands. Roads through PSWs are proposed for a future phase of the development. Roads at risk of being allowed via that misstatement. So it needs to be retracted before this project proceeds any further. Second issue, bait and switch of PSW buffers. The OPA came with a long list of conditions, mapping changes and studies, reports, permits required at various stages, what Chair Johnson called hoops to jump through. Top of that list was NPCA's recommendation that the PSWs located on the subject lands be designated environmental protection area, including a 30-meter buffer. That OPA was the policy framework for any future development. But in reality, as stated at that first meeting, if 30-meter buffer required, the development cannot work. So in contravention of that OPA, the developer submitted a draft plan of subdivision proposing PSW buffers of 10, 15, and 20 meters with roads cutting into those buffers based on their own environmental impact study with no independent peer review. So with no way to counter the developer's claims, NPCA staff responded by cutting required minimum PSW buffers in half, from their own recommended 30 meters to protect this wetland complex to a mere 15 meters based on a long list of exceptions introduced by the former rogue regime. That regime is gone, but its bad policies remain. In this era of climate emergency declared so by this board, rogue era exceptions to the 30-meter rule must end. Reality has found a way of catching up with the NPCA. The Auditor General exposed a disgraceful legacy on this file, repeated attempts by senior management and board members to allow wetland destruction in contravention of provincial policy, not based on any scientific analysis. At this stage, it's up to you to change that legacy going forward. and it's an urgent matter. Staff is in the process of making final comments on the proposed subdivision. Those comments will determine the fate of this massive forested wetland complex. I urge this board to put a temporary stop work on this file until you review, revise, and remove rogue policies still in place to restore the ability of NPCA staff to enforce real protection of PSWs, stand firm on minimum 30-meter buffers, no exceptions, no roads, and end the farce of bait and switch by developers. I also urge you to advise the city involved that an independent peer review of the environmental impact study is warranted. As of last summer, the developer quietly listed the entire property for sale/investment opportunity, but plans are on the table seeking approval to continue. And the time to act to correct past wrongs is now, to prevent more destruction of natural heritage features that should be protected. It's the only way to restore public trust lost on this file. Thank you.
Thank you, Linda, and thank you for staying under the 10 minutes. We really appreciate that. So now I need a motion, please. Go ahead, clap. All right. A motion, please, from Member Houston and seconded by Member Ingrao, that the presentations related material from the following individuals be received. All those in favor? Thank you, everyone. Now we go on to, and thank you again, delegates, for coming. So now we're on to consent items, folks. Oh, sorry. Where's David? David would like to come back up here again. I have to go back and get that, sorry.
Just to brief board members on where we are on this one.
Thank you, David. And again, after hearing the solicitor's advice, David has geared his presentation regarding this file. Thank you, David.
Thank you, Madam Chair. So again, this is just, this should be quicker than my first presentation, a quick overview of where we've come from with the current Thundering Waters proposal. There was a previous proposal from 2008. I'm not discussing that proposal. That's been approved, dealt with. There's a new proposal on the table. So all the comments on this presentation are based on 2015 forward. So the NPCA's first involvement with the current version of Thundering Waters was in March of 2015. We were involved in an initial pre-consultation meeting, which was to set out what requirements would be for an application to proceed forward. During the period between March 2015 and September 2017, NPCA staff were participating as a member of the Secondary Plan Steering Committee. And our role in that was overseeing the development of a Thundering Waters secondary plan. And when I use the term development, I don't mean in developing the property, I just mean in creating a secondary plan. September 2017, the applicant basically abandoned the secondary plan process and chose to file an individual official plan amendment application to the city. April 2018, the NPCA provided comments to the city on that official plan amendment application. In July, the City Council approved the application. August of 2018, the official plan amendment was appealed to the local planning appeals tribunal, and later on that appeal, as recently as I believe it was October 31st, 2019, the appeal was dismissed by the LPAT. So moving forward a little bit, different process. March 2019, applications were received by the Conservation Authority for zoning bylaw amendment and a draft plan of subdivision from the city pertaining to the Thundering Waters property. So in May 2019, the NPCA provided comments on the application. Essentially, we identified that there's insufficient information to be able to support the applications. September 2019, updated information was submitted in response to all agency comments. November, the NPCA advised that the information is still insufficient to be able to move forward with applications. December 19th, new information, updated information was submitted. We are still currently reviewing that information, so comments have not yet been sent to the city on that. Again, under current review. So just quickly, this is the existing Thundering Waters property, or I should say most of it. There's still an area to the north up here that is not shown on the map, but that is also part of the property that's not identified for any development. The area we are dealing with under the current applications is in this area here. So just wanted to clarify a couple of issues. This morning we were speaking about the policy hierarchy. The provincial policy statement does not have any prescribed setbacks from PSWs. It prohibits development in PSWs, but it simply leads to a test of no negative impact to the wetland to ultimately determine what is an appropriate buffer. The Niagara Region official plan similarly prohibits development in PSWs, but again, it does not prescribe a specific minimum setback for PSWs. The City of Niagara Falls Official Plan Amendment 128, so that is the site-specific amendment that applies to the Thundering Waters Phase 1 property. And the text you see there is verbatim from the policy. So it says, a 30-meter buffer shall be established to protect the ecological and hydrological functions of natural heritage features. The 30-meter buffer may be increased or decreased based on an approved environmental impact study required through the subdivision and development application process. So that would include subsequent zoning bylaw amendments or site plan control applications that may come in the future. So again, the policy framework is there that the 30-meter buffer could be reduced, but only where there is scientific information that is supported by all agencies and agreed to support such a reduction. So the NPCA policies, both current and previous policies, they do prohibit development within a PSW. One exception being because we have the unique ability to deal with site alteration, which a zoning bylaw doesn't deal with, but for example, passive recreation, a trail, that's something that could be entertained in certain circumstances in a PSW through a work permit with us. Setbacks to be established for wetlands are to be based on sound technical information, so you can't just say that for a subdivision, oh, okay, we want to have a 10-meter buffer, give it to us. No, you have to provide a study that shows why whatever buffer you're asking for, if it's less than 30 meters, meets the intent of the policy. So the NPCA policies start off with a 30-meter buffer, and the reduction of the 30-meter buffer, again, is only allowed where additional scientific information demonstrates no negative impacts to the ecological and hydrological function of the wetland. And again, NPCA policies, as we talked about this morning, they aren't out of line with other conservation authority policies with respect to wetlands.
Thank you, David.
Oh, sorry, it's just...
Go ahead.
Okay, sorry. City of Niagara Falls, again, has given us an extension for providing comments. Initially, I believe the deadline date was February 4th. We have had discussions with the city, and we've sought an extension, and we've been granted that. So we basically have whatever time we need to complete our review. No decisions have been finalized regarding the zoning bylaw amendment or the subdivision applications. Again, those are council decisions. And the NPCA staff, again, we're reviewing the most current submission, and once we've completed our review, we will be providing our comments on to the city. Thank you.
Thank you. And just to remind everyone that we're not to ask any questions that may impede the investigation that's ongoing currently. So, Member Metcalf, do you have any questions for clarity on the presentation?
Thanks, David. On the 30-meter setback, so if the NPCA recommends a 30-meter setback, but the municipality recommends less, who trumps who in that situation?
David?
For lack of better.
General question.
Thank you, Madam Chair. Through you, it becomes a tricky situation because when you're dealing with a Planning Act approval, that is the municipality's responsibility. We sort of touched on this morning the potential for a conflict with a municipal decision and a conservation authority's policies. So if a municipality were to approve something that we do not support, if we said, okay, you have to have a buffer of X, they give a buffer of Y. In that case, then you could either, as the board, decide, okay, we need to appeal that decision, or if it's left to stand, then you would be in a situation where permits would be required of that application or future development based on that application, and we would not be able to support those. And then again, that could potentially push the board into a hearing and further litigation.
Member Metcalf, are you? Thank you. So Member Smith?
Thanks, David. You mentioned, I think 2 slides back, that provincial policy doesn't mandate 30-meter setbacks. Of course, in the public, and I'm going to even throw myself into this, in my mind, 30-meter setbacks has always been the policy minimum, being actually allowed to be extended out to 120 meters to ensure that there is no negative impact to a provincially significant wetland. So if there is no provincial policy, where did that notion come from?
Sorry.
Through
Go
you,
ahead, David.
Through you, Madam Chair, from what I can understand, the 30-meter buffers, and I'll speak to a Niagara context. Back in 2004, when the province announced that, okay, we're moving forward with coming out with generic regulations for all conservation authorities across the province, conservation authorities were asked to draft a regulation for consideration. So at that time, the province was providing guidance now, not so much setbacks, but for areas of influence. You mentioned the 120 meters. So that is the area of influence within that's identified in our regulation. That's essentially as far out as a conservation authority can regulate from a provincially significant wetland. During the discussions, the Conservation Authority had at one point pitched to the province in its draft regulation having an area of influence of only 30 meters. Now that was based on, from my understanding, sample environmental impact studies, and it was stated that, okay, and this is just going from a staff report, I wasn't with the organization at that time, but that most EISs did not recommend buffers beyond 30 meters. 30 meters was sort of the maximum, so they felt that, okay, this would be an appropriate area. But there were buffers that were being recommended less than 30. Long story short is the province didn't agree with that. They wanted the area of influence to be the 120 meters. And again, we're not dealing with setbacks. This is just the area in which you're beginning to look at applications where you need to be concerned with. And the province had advised the Conservation Authority at that time that through their policies, they can prescribe whether or not you have 30 meters as your starting point or what you need to do between 30 meters and 120 meters.
Thank you. Member Smith? No, thank you. So thank you very much, David. Really appreciate you clarifying a few things for me. I'm just taking off the top, right? Yep. Getting to know him. So it's moved by Member Ingrao and seconded by Member Metcalf that both presentations that David gave us this morning be received. All those in favor? And it looks unanimous. There we go. Thank you very much. Now we're on to consent items, folks. And I do have, sorry. So the following reports to be received. Are there any questions on the partnership, community engagement, and events? Member Hewson.
Thank you. The report, partnerships, community engagement, and events made reference to board members facilitating engagement. And I'm wondering what role we can take and how you envision that we facilitate more engagement. Page 44.
And I'm going to let Renee answer that, please. Thanks, Renee.
Through you, Madam Chair. Thank you for your question, Member Hewson. You are all here because you were put here by the citizens. And we want to encourage board members to be involved in everything that the NPCA is doing to engage the residents in our watershed. You are all very busy and you do have important roles here. However, there are a lot of opportunities that we would love to encourage you to be a part of. It could be as simple as retweeting an event that's up and coming. And it could be, you know, you want to volunteer maybe at something. It could be perhaps the chair or vice chair is not available at a particular event and we need someone to bring greetings on behalf of the NPCA. Really, the opportunities are endless. And so that is the purpose of this report, is to let you all know that we will welcome you with open arms. Whatever you are able to do, we will gladly take your time. And that's basically it. Thank you.
Thank you. Any other questions for partnerships, community engagement, and events? Seeing none, then we'll move on to the NPCA policies. Well, I'm assuming we're moving them all at once? Okay. Policies. Is there any questions on that report? Is to be received. Seeing none, thank you. Then we'll go to spatial data, open data launch. Are there any questions on that report? Am I going too fast? Oh, good. Next.
The reports are really
Thank you. Now the last report, Greenbelt Council for the Greater Golden Horseshoe reports regarding the value of watershed planning and management. Any questions on that? Member Hewson.
So the report specifically talked about the need, a fourth mandatory area that was being recommended in terms of leading and facilitating interjurisdictional collaboration at the watershed scale to protect and improve watershed health. Is this not something that's already happening? I thought with Conservation Ontario and our collaboration with the Conservation Network that we would be undergoing this to some regard at all. Is that something you can comment on?
Chandra? Jeff. Sorry. Jeff?
I'm not entirely sure at the conservation level. I think this was just a recommendation from the Greenbelt Council at this time.
Member Hewson?
That's fine.
Thank you. Any other questions? Seeing none, now I need a motion, please. It's moved by Member Metcalf and seconded by Member Angreo that all four reports to be received. All those in favor? Thank you. So now we are on discussion items. So the first one is that report number FA0220, re the 2020 restoration project approvals be received, and that the approved restoration program 2020 projects and associated funding identified in Appendix 1 of report 2020, entitled Restoration Projects and the 2019 projects carried forward be approved. Are there any discussions on this report? Holy cow, must have gave you some gravel before you came in. All right, so, yeah, your guys are all drugged. So moved by, they're probably afraid to talk. Member Shurton and seconded by Member Angreo that the report be received and that it be approved. All those in favor? Any opposed? Seeing none, thank you. Now we have report before you is FA-03-20, the NPCA Public Advisory Committee be received for information. So I need that to be received. All those in favor, right? So we got it all here. Sorry, who's this?
Sorry, we also have the appointments. That was the
Yeah.
closed session matter. So.
Who's this?
Like, no,
You guys have got to. Oh. And I can't take that one now, so we got to do someone else. So this, and also that the NPCA Board of Directors appoints the individuals that are identified in the confidential Appendix 1 to report FA-03-20 as the members representing the following sectors of the NPCA Public Advisory Committee: Public at Large, Agricultural Value Added, Agricultural North, First Nations. If there's any discussion about any of these individuals, we'll need to go in camera. If not, we can approve it today and make it public. So, Any questions? Anybody need to go in camera? Seeing none, that we make it public and that the confidential Appendix A or 1 to report FA-03-20 be deemed a public document and received into record. It is moved by Member Woodhouse, and I'm going to put Member Beattie as the seconder because our member Bilsma just left. All those in favor? Thank you. And congratulations to those individuals. So this is a report now, FA-04-20, re the 2020 capital projects Bimbrook be received. So are there any questions on the Bimbrook report? And I believe in our, it's 9B. Are there any questions? Member Brady.
I've read the report and I think I understand it, but just for clarification, I could ask the author. So we're going to move forward with a study with monies that are being directed out of a capital reserve, as far as I can see, about 80,000, but we are not going to be moving forward with any actual capital project until such time as there's a finance mechanism in place. Is that fair?
Lisa?
Through you, Chair. The study, and I will ask Steve Miller to provide some detail, is more the engineering design so that the project can start to move forward pending the final approvals in terms of the financing. But if for additional information on that particular engineering study, I will ask Steve Miller to speak to that.
Member Brady, would you like Steve to speak to that?
Not directly. Okay. I just wanted to be clear that what we're approving today is to deal with the study, the engineering study as per se, but that further information will be brought to us in terms of any implementation of that, in terms of how that'll be financed.
Lisa?
That's correct.
Thank you. And Member Clark, and then Member Smith.
Yeah, so with regards to the City of Hamilton, so the finance staff and the council are willing to entertain a debenture type financing agreement, so we just have to negotiate that type of financing with them that would be paid back over time. But I don't see any opposition at the other end. It's been done before with the Hamilton Conservation Authority, and it's done quite commonly across the province. So,
thank you. Member Smith?
Speaking to the debenture issue, I guess, more than anything, I have a concern, and maybe I just don't understand how it works specifically. So if we debenture this project, and then we have to use, I'm going to use the word profit.
Yep.
If we use profit from the Bimbrook operation to pay for the debenture, is that profit that could have been reinvested in the organization to, for instance, hire staff?
Good question. Lisa?
Through you, Chair. Actually, the debenture financing and the debt servicing costs going forward will be outside the municipal levy calculation so that it will not impact the municipal levy for operating expenses going forward. So consequently, and that's the terms of the MOU that would be struck or would be under discussion with the folks, the Hamilton finance staff, to make sure that operations would not be impacted in any way by this particular funding mechanism.
You still have the chair, Member Smith?
No, I'm not totally comfortable with this, but what I take some solace or comfort in the fact, and Member Brady's question when he asked, right now today we're approving the engineering study, the $80,000, and then we'll go into a more in-depth issue about the financing of it in the future then?
Lise? I'm sorry.
Yes, that's correct. Before any formal debt financing mechanism is approved, it would come back to the board.
Thank you.
Thank you. Member Clark? Oh, for the second time. Anybody else for the first time? No? Thank you. Member Clark?
So if I may stress the need for expediency, my personal concern understanding the file is that if the septic system fails and provincial orders are issued, they are going to have higher costs we have to act proactively and as quickly as possible, given the increase in volume of visitors to the park, and that the septic system at the present time does not appear to be able to handle that increase in volume of visitors. So getting the engineering study done quickly, making sure that it's properly done, and then getting the financing in place. This is an important issue for the ongoing viability of that park.
Any other questions before? Oh, thank you. Member Halenga?
Comment first. I see that there is a suggestion that this be, the entire project be phased. And in view of the fact that our budget allocation was reduced, that we can cover it in our budget allotment.
So the first question is, will it be phased? And the second one is it within our budget, correct?
That is how I read it, so I just
I'll
want
go to
confirmation.
Lise for question 2. Lise, is it in our budget allocation?
Through you, Chair, yes, it is. The entire project, and it's phased or otherwise, was originally proposed to be $1.5 million, and that is indeed what we're going forward with. The phases of the project may fall out of the engineering study, and then we would review that study at that time as to how best to move forward in light of the financing mechanism as well.
And Member Halenga's first question, who would like to answer that, Adam or Steve, about the phasing in possibilities? Steve? You got the microphone, Steve.
Great. Thanks. Through you, Madam Chair. It was thought the septic system was based on the 2014 Binbrook Master Plan. The master plan showed projected an increase in attendance to the park. In addition, it recommended that as part of the 10-year plan, a campground be envisioned and a multi-use building be proposed. What we're looking for is a system that can go in that would meet the anticipated increase in usage at the park, but is also modular in nature. So if and when the campground, the multi-use building are contemplated and are going to be built, that septic system can be easily expanded to accommodate those buildings at that time.
Member Halenga? You still have the floor.
That satisfies my question, because I didn't think we need to spend what we had budgeted if it's not, and if it's to service something that isn't built at this time.
Correct.
Thank you.
Any other questions? All right, thank you. And it's moved by Member Woodhouse and seconded by Member Beattie that report FA-04-20 read 2020 capital budgets Binbrook be received, and 2, that the board authorizes the staff to explore financing options with the City of Hamilton, including debenture, financing and related future debt servicing commitments, and 3, that the board authorizes the staff to utilize residue capacity within the 2019 approved capital budgets from reserves to initiate the engineering design of the septic system and to facilitate MECP approvals, including municipal site plan approval. Once financing is secured, capital reserve will be replenished. And further, that the board authorizes staff to proceed with the next steps / action items outlined in report FA-04-20. All those in favor? Thank you. That's anonymous. And now we're moving on to motions. As you heard earlier, the motion that was from Member Kaywall has been withdrawn at his request. And we're on to the second motion by Member Smith, who I believe wants to speak to it.
Thank you. Yes, so I want to give the preamble or the oversight of that motion. In no means is that motion meant to be reflective of anybody on this board or on this staff or in this organization. I view it as a motion that has importance for a couple reasons. One of them being it sends a signal to the public, because regardless of what we think as board members, I'm very engaged with the public on NPCA issues, and I know all of us are, but I mean, the public feels free to talk to me in a, and I'm glad they do, by the way, in a hypercritical fashion about the NPCA. And so I hear a lot of thoughts that maybe are not, do not pervade for all of us. I think it's important that we send the signal that we're aware of what's going on, and because a lot of times we talk about on this board about not looking back, we're only moving forward. But we may be dragged backwards. There may be a police investigation that it comes knocking on this door. We don't know that, but this is definitely sending a message that we intend to cooperate with anything that's coming our way. There has been pushback by board or by people that have said, well, that's expected of us as board members, as staff members of this organization. I agree with that. But unfortunately, this organization does not in the recent past, and I'm going back before have a high reputation for living up to what is the public expectation of its public institutions. I think it's important for us as a board to say, no, we are different. If I even go back, there was even some controversy, I'm going to say 6 months ago, I think it was, maybe 9 months, about when the ombudsman was trying to do an investigation here. And I don't want to discuss all the what happened or the he said she said aspects.
She said.
Yeah. I just think it's an important motion. I think it's an important signal for this board to send.
I had Member Clark, I believe, and Member Foster. Member Clark?
I respect and I understand the sincere intentions of Member Smith with regards to the motion. And the challenge for me is that the motion has implications. The implication is that our staff won't be forthright with a police investigation unless they're directed to be forthright by the board.
Right.
And that's completely inappropriate. It's not necessary. And it's not even based in anything in terms of jurisprudence and law enforcement in Ontario. At the end of the day, the police have the right to investigate. They will meet whoever they wish. They will interview whoever they wish. And any individual that is not forthright or withholds information or tries to destroy information, there are laws that the police will utilize and through obstruction. So I understand the intent. I think this board has been more than forthright in its desire and sending messaging that we have moved to a very transparent good governance-oriented board. Our policies have changed dramatically between whistleblower protection, code of conduct. We've made significant advances and changes to our procedural bylaws and our policies for employees. And we're demonstrating as an organization that our integrity is important as a board and our integrity is important as staff. I think the unintended consequence, and I hear the member argue that that's not the intention, but the unintended consequence of passing this motion is that we're basically directing staff, you must cooperate with any police investigation. I don't think we have to do that. We have codes of conduct for staff. We have codes of conduct for our board. We have set the expectation, the standard under which this organization is going to operate. And I think it's important that we live by that standard. And I think giving that direction means for some reason in the back of our minds, we think that there's someone around here that's not going to cooperate. And I don't want to leave that message. My full expectation is that staff will cooperate and that board members, both here and on the past board, will cooperate with the police investigation. And should they fail to do so, they do so at their peril. So I can't support the motion.
Thank you. I have Member Foster, Member Halenga, and Member Beatty. Member Foster.
Thank you, Chair Johnson. So two things with this. Number one is that I actually like what it is that Member Smith is trying to do. This is a public statement that's coming out concerning this from this board, basically saying we know and understand, and we're very much willing to do our part as we're going on with anything that's going on. And I also hear Member Clark's commentary on this as well. My suggestion with this, to be honest, I cannot support the motion as it currently exists, only because there's too many whereases in it that I think, number one, are difficult for us to basically state. My preference, if we're going to pass a motion at this particular point in time, is if we go with what it is that Member Smith is trying to do, which is basically stating we acknowledge this Ombudsman report has come out, we acknowledge that it's been passed on to the police for investigation, and therefore we resolve that if it's required, the NPCA will work with it, period. That's the political statement that's going on at this point in time. So some of the whereases, unfortunately, it's difficult for us. I know where Member Smith is coming from, but they're not based necessarily in fact. It's more opinion that's going on with things, even with the results of the Ombudsman report. So we do have to be careful with those types of things. So,
thank you. Member Halenga?
I seconded this motion, and I did so for the reason of transparency. I think that despite the fact that we assume that staff will do the right thing, that they will cooperate, what does the public see, and what statement do we make for that? And I think this is a statement in transparency. Maybe it doesn't have to be in a formal motion, but it certainly should reflect what the board expects.
Thank you. I have Member Beattie, then Member Woodhouse. Member Beattie.
Thank you, Madam Chairman. I support Mr. Clark's position in that this motion is not necessary. This organization's already been through an OPP investigation and cooperated fully to the best of my knowledge. So who would not cooperate with the OPP? I can't envision it. And also at the end of it, I would ask for a recorded vote, please.
So noted. And Member Woodhouse?
Thank you, Madam Chair. I can't support it either. I do understand which has been stated opposite the position and the logic and the reasoning why. However, we all have obligations professionally. We all have obligations that we've sworn to the various legislative requirements. But on the other side of it, our staff and everybody involved here have individual rights under law. And I wouldn't want to be seen as putting anybody in a position where who knows what an investigation individually goes against them. Their rights should and need to be protected, I think, in this case. I agree with the general desire to put forward a position of openness and transparency in a police investigation, and believe me, I've been through a lot of them. The fact is the police are legislated and have authorities beyond this board and individuals. So I think it's probably best that we not support this. We've already taken an approach of being open and available for any and all. I think that's fair to say. This new board has been quite remarkable. Our staff are exceptional, and I just don't want to put anybody in a position where there's an implication that if we don't pass this, then we're somehow trying to impede people's position through an investigation. Investigation, if it takes place, it'll take place as it does all investigations, and the police will do whatever they have to do under their legislative requirements. The individuals involved will be allowed to have legal protection to ensure that they individually and collectively are protected by that same law. So for that reason, I can't support it, unfortunately.
Thank you. No other questions. I heard recorded vote. Oh, sorry. Member Smith for a second time.
Yeah, and thank you for giving me the last comment on this, since it was my motion. So I heard everything that was said, and actually, here's the oxymoronic position I'm in. I agree with everything that was said on both sides. I really do. This is a really difficult, and I actually liked Member Foster's suggestion for the rewrite. Just simplify it and say, I want to try to put in your head a situation that's maybe for most of us here unimaginable, because we sit here in good faith and say, we don't do that. We cooperate with police investigations. And I know that everybody in this NPCA does. However, there are documents that could be, I'm going to use myself. There are documents that could be in my possession that I might need to turn over to a police investigation. Nobody here knows what those, and I'm not saying I have them. I'm saying I'm using myself to deflect the attention from any other implications. This is really hard for me to discuss, but I think that this is important. I think this is important for us as a board to make a statement that we support anybody coming forward with any information they have that they in good faith believe is germane to a police investigation, whether the police come to them or not, because the tricky part is saying, of course we would all cooperate if the OPP came to you and said, sit down, I have some questions. But if the OPP doesn't come to you and you are acting in good faith, and you are an employee or a board member of this organization, are you risking yourself?
I think this will be the last speaker. Second time, Councillor, or sorry, not Councillor, Member Clark. Microphone, please.
Thank you, Madam Chair. And I hear Member Smith's clear desire. And I'd like to suggest two things that we need to consider. One is that the police have subpoena power, and they have the power to get search warrants. So it's not a question of cooperation when a subpoena is issued, or a question of cooperation when a search warrant is issued. So it's important that we understand the level of authority that the OPP have should they choose to investigate. So that's one. The second point, and I need to go a little bit further to where Member Woodhouse was going. This motion is saying that we're directing and we're wanting full cooperation from our staff. I think there's only, who's on this board now? Just Stu?
And
so there's two members that were present from the previous board. The rest of us are all new. So we really don't know what transpired. And I don't know, as an individual here, whether or not staff were directed to do things that were improper, but were under threat of termination if they didn't act. And to pass a motion where we're saying to our staff, you have to cooperate with the police, when they have a right to counsel and they have a right to seek defense, and to ensure that they're being fairly treated by the court system, I think we have to be careful. We shouldn't be directing staff to cooperate. We shouldn't leave it an expectation to them that if they don't cooperate fully with the police investigation, even if they're in a situation where they were directed to do something, and if they didn't do it, they could be terminated. So there's some exoneration and issues that, contingencies that need to be considered by the courts. We're putting them in an untenable position, and we shouldn't be doing that. We should allow the police to do their investigation. If a staff person feels that they need outside legal counsel to protect them, they should have the right to do that, and we shouldn't be directing them to cooperate in any way, shape, or form. It is a police investigation. It is independent of this board. We should not be injecting ourselves, inserting ourselves in any way, shape, or form into that potential investigation. And we don't even know if there is an investigation. We know that one was asked for. So I understand all of the concerns. I understand the issue of transparency, but we need to balance it overall with probabilities and respecting our staff and respecting our board colleagues to ensure that individual rights are being protected. And at the end of the day, the police will do what they do. We've made it very clear we're transparent, and we're going to continue to be a board that operates with good governance.
Thank you. We still have first-time speakers, Member McKenzie, then Member Fior, and then I'm going to go back to Member Foster for a second time unless there's another. Go ahead, Member McKenzie.
Thank you, Chairman Johnson. Member Smith, it's without due utmost respect of your work that I speak of today. I won't be supporting the motion, but I think everybody, including yourself, if not most yourself, can walk through this community with pride. I came across an interesting statistic the other day. Of all the conservation authorities in Ontario, 426 board members sit on those boards. Out of those 426, approximately 385 of them are politicians. So that leaves about 40 or 45 citizens that sit on conservation authority boards across all of Ontario. This board represents 11 or 12 citizens, a third of the citizens across Ontario's conservation authorities. To me, that speaks volumes about what this community has said in terms of support of this motion. We don't need to make the rules in detail like you have suggested. I walk in the community proud, and I know you do. And that's what I think guides us. So that's... Thank you.
You can turn your microphone off. Member Fior.
Thank you, Chair, and Member Smith for bringing this forward. I do appreciate it. However, in its full form, I would not be able to support it. But I have a question for the CAO. Maybe you can lend me some insight on this. I know that we approved a whistleblowing policy. And I see on the website that we've made a statement of this new whistleblowing policy. There was even some media coverage on it. I'm wondering how this policy was communicated to staff. Was it through a memo? Did you have a team meeting to discuss it? And have you interacted with staff on this matter? I do realize it came forth before you came on board, but has there been any communication with staff on the new whistleblowing policy?
Thank you. There was some mention about the whistleblower policy earlier. CAO?
I can first ask
Microphone.
Comment on that because she's the keeper of most of the human resources policies, and yes, this was before my time, but I can always add to that as to what my plan is going forward on all of our policies.
Through you, Chair. So the policy was sent out through email to all staff to make sure that everybody had a copy of the updated policy. Since that time, we have not yet had an all-staff meeting to review the policy in detail and gather any questions. All staff were encouraged to bring any questions, comments, or any other feedback forward, and we will discuss the policy at any upcoming staff meeting to ensure those questions are addressed, whether individually or as a group.
Thank you. Member Fior? You're finished? Okay. Oh, thank you, Chandra.
And going forward, we will have quarterly staff meeting, and there'll be a training component in those meetings, all staff meetings on some of the major policies. I'm also envisioning an internal, like intranet site where we will host all these policies, and reminders will be sent to staff to continuously review them. And this is an internal communication location. Yeah, thank you. Okay.
Thank you. And we have two more second-time speakers, and then we're going to go to the vote. Member Foster, and then I have Member Halenga.
Thank you. So it doesn't sound like this is going to pass the way it currently is, and so two things with that. One, and I believe I've spoken to it, so I can't refer this back if I'm not mistaken with the rules of procedure, but perhaps maybe to Member Smith that it might be a consideration to withdraw this motion at this point and work with staff to come up with a motion that accomplishes what it is that I think Member Smith is really trying to accomplish here, which is a political statement on behalf of the NPCA in this area. So.
Okay, so there's a suggestion. I'm just going to go to Member Halenga.
I said that I seconded the motion because I wanted transparency. Now that this discussion has taken place, I think it's pretty obvious what our position is, how transparent we intend on being. So I'm prepared to remove my seconding of that motion.
Thank you. So now we have a motion on the floor without a seconder. Member Smith.
A point of order. I don't think,
Yes,
unless
he can.
I'm mistaken, he just votes against the motion. He can't. A seconder puts the motion on the floor for discussion.
And he can
If
remove his
removes
name.
it, that
Yes, he can.
effectively stops the discussion.
He can
Because we
remove,
don't have
and
a
that's why I
seconder.
just said, Member Smith, you don't have a seconder now. He's removed his name. Do you have a seconder for your motion? If you do, are you seconding the motion?
For the purposes of...
Okay, so you have a seconder for a motion. So are we ready to do the vote now? Yep. Okay, so we're having... No. So you had your hand up, so I'm just making sure that you had your concern answered, and we're going to the recorded vote. Thank you.
Yes.
So I'm going to turn it over to the clerk.
Thank you, folks. You have the motion in front of you. Does anybody require me to reread it? Okay, then I'll call for a vote, recorded vote, alphabetically. Member Beattie? No. Member Brady? There's no member Bills. Member Clark? No. Member Cridlin? Member Fior? Member Foster? No. Member Halenga? No. Member Hewson? No. Member Ingrao? No. Member McKenzie? No. Member Metcalf? No. Member Rapley? No. Member Shurton?
No.
Member Smith?
No.
Member Steele? Obviously. Member Woodhouse?
No.
Member Wright? And Member Johnson? Motion fails.
Thank you. So we're finished with motions right now. Is this under other business, Member Halenga? Can you put your microphone on, please?
As Member Woodhouse reminds us frequently, it is to the benefit of the board if we show unanimous support, and I commend Member Smith to contribute to that. Greatly appreciated.
Yeah. He doesn't like it when you congratulate each other, do you?
Yeah, I'm
That's
not
right.
even sure I'm deserving.
Thank you. So now, notices of motion. Seeing none. New businesses. Oh, sorry. Oh, here we go.
We're going there. Having heard the presentations that we heard from the public today and not having been able to question them, I am considering a reconsideration, bringing up for a reconsideration in December. On December 18th, this board decided to defer the, I'm going to call it the review of our green policies. Having heard the frustration of that, I'm considering bringing it up for a reconsideration in March.
Okay, so right now we've just been put on notice for a notice. Any new business, I'd like to refer to, just for a second please, our CAO to comment on our event that we went to on Friday with the stakeholders, with the minister.
So thank you, Madam Chair. As you are aware, the province is hosting consultation sessions in regards to Bill 108 regulations, and there were 3 sessions held. The one in London was the last one, and there have been one in Barrie and one in Coburn. The session itself was well attended, over 300 people, and I can say what I hear after the fact was that this was the most positive session in terms of Conservation Authority support. So the presentation made there by Ontario Federation of Agriculture, Ducks Unlimited, and AMO, Association of Municipalities of Ontario, were all very complimentary of conservation authorities and the work we do on the ground. And in fact, a statement was made that none of these stakeholders are requesting a wholesale change of Conservation Authority mandate, but they just want some things fixed, standardized policies and standardized regulations. So that was very heartening to hear. I think the province, actually the minister was there who himself said that. So that was very good, and I complimented him after the fact. Chair Johnson was there, Member McKenzie, Vice Chair McKenzie was there, myself and Darren attended the session. Each of us, through Conservation Ontario, at every table, we provided our input on what these regulations may or may not look like. It is my understanding that the province is thinking of coming up with something by June. So stay put, and I think we're seeing a lot of support from municipalities on, on this matter. They're sending letters out. We talked about it earlier in our meeting. I would really request that if you have an opportunity, talk to your staff and at each of the municipality and allow us to work with them to send some positive messaging to the province in support of Conservation Bill 108. Thank you.
And just on that particular event, Member McKenzie just wants to add to that.
Yes, thanks, Madam Chair. One question and a comment. First question is there was an email that went around from GLO Ontario that was a survey with all those questions. Was that distributed to all of the board members?
Can I answer that?
Yeah.
Yeah, so thank you for the reminder. Thank you for the reminder. That's very good. The link to the survey has just arrived, I think, yesterday. I am planning to circulate to the members and all of our stakeholders. So if you have an opportunity, please fill out the survey and send it to the province. Thank you.
Thank you. And my comment was, I was very pleased to be there and to hear the positive comments from the minister and the stakeholders. But I felt there was a large stakeholder not in the room, and that was the users of our conservation areas and the citizens. They weren't represented in the room. I'm not really sure how they would be represented in the room because they're not a stakeholder. But I noticed the absence of them. I hope that the process that the Minister of Environment and Conservation and Parks the process that they're going through now is that the citizens and our conservation area users are not absent when it comes to comments made to the provincial government. I think that's critical because the enjoyment that families have and the educational values that are available to the public through our conservation areas and our programs was not highlighted at that session. So I put that out. If we can spread the word that the government is looking for feedback, I think it's incredibly important to get it from our users and the public. Okay. Thank you.
Just your microphone is on. Thank you very much. Yes, it was very informative day. So, Member Foster, before we go.
Yes, thank you, Chair Johnson. So, just a quick update. We had a foundation meeting earlier this month talking about next steps that are going on there, and we are going through a recruitment process, or we started into that. I believe we had originally planned on coming in to talk to this board about the foundation this month, but it's delayed. And Renee, I think we delayed it to April, I think? Yes. So we're going to be coming in April to give a full report to the board on where we're at. But what I would like you guys to do is circle your calendar on April the 29th. We're going to be doing a meet and greet with the foundation at Bench Brewery. Bench has agreed to host us for an evening there. So anyway, please circle that because I would like to see board members out to that. Thank you very much.
And Member Woodhouse? Thank you very much, Member Foster. Great article in the paper, by the way, for that.
Thank you, Madam Chair. I was in attendance at that meeting as well in London, and I can tell you the other thing that they had actually extended another session they were going to hold in Sudbury after that to represent the North. I think the comment was made. But I would really echo the comments made about the opportunity for people to participate in this, and this is your chance to really get your 10 cents worth. You know, everybody likes to be critical of things after the fact. Well, now's the opportunity. The government is very open, very accepting, and they want to hear from everybody. So to the general public, to all members of the board and others who have interest, please do take the time to, you know, put your understanding and needs forward. Thank you.
Thank you. And seeing no further business, I'd like to announce. Oh,
one more update.
One more update.
Renee, you want to talk about the volunteer night?
Renee?
I actually had thought about mentioning this earlier, and I regretted that I hadn't. So, of course, many of you should have received an invitation by now. Next Wednesday, we will be recognizing quite a few hundred volunteers this year. Out of our volunteer roster of 1,350 on our roster, we had 700 and I believe 91 of volunteers actually engaged with our organization in 2019. And we've doubled our attendance at the awards ceremony this year. We have 340 volunteers who are coming out. That is a huge increase over the past few years. So I think that sends a clear message that we are all still working together. So please, if you have the ability to come out, we would love to have you come out to the event to show your support. There's going to be, we've invited some of our partners to actually be the keynote speakers this year to talk about their projects and how they're having a positive impact on our watershed. So thank you for the reminder.
Member Woodhouse?
Yes, specifically to that, I think that it's fantastic, and it struck me as the number of letters, phone calls, emails, etc., that we've been getting about a number of from concerned citizens. I think is another opportunity in which we should maybe extend an invitation to those folks to join and give foundation information. There's an opportunity to help here, and I think that it would be well received, and a lot of these folks may not even know this opportunity exists, but I think we should open up and make these offers to them and see, give them an opportunity to participate. Thank you.
Thank you. So now that there's no further ado, please, all your blue papers, can you please turn them all in? And I'd like the following motion to adjourn after we congratulate Farmer Chair Bilsma of being a grandpa. He just turned a grandpa on the weekend. Member Shurton and member, okay, who's this one?
Ingreo.
Member Ingreo, that the meeting be adjourned at 1:30. All those in favor? Thank you, everyone.